The Honorable Chief Justice and Associate Justices of the Supreme Court.
The House will come to order.
The Senate will come to order.
.230 is next. And I think Representative Reiner, you're going to cover Representative Wayne on this. I was trying to locate you. Hey, John. Representative Reiner, I think you had some folks that are here to. I know we were trying to accommodate some schedules here. I know there's some folks here to testify with you. They're welcome to take a seat with you if you need to.
Thank you. Thank you, Mr. Chairman, ladies and gentlemen of the committee. I'm just going to give a short overview of House Bill 230. Sorry that Representative Wayne wasn't able to be here today to present it. His mother, he's with his mother. She's in the hospital. This bill is an effort to restore public trust in the judiciary. We've had several situations that have developed that have brought national attention as the infusion of big money and special interest in state Supreme Court races has reared its head. In West Virginia a couple of years ago, some of you may remember that it was a judge who had received $3 million in his reelection campaign, and then he ruled or actually overturned a $50 million verdict against the company that this fellow directed. And so the U.S. Supreme Court says that the conflict of interest was so extreme that the judge's failure to recuse himself amounted to a violation of the civil rights of the plaintiff. So we hope to prevent that sort of thing from happening in this state. After the Supreme Court allowed unlimited spending by special interest groups in elections, there's more need than ever to address this problem. So what we have done in Section 1, we have, through definition, we have limited the judicial races to those candidates who are running for the state Supreme Court. In Section 2, we've established public financing where judicial candidates choose to participate in the financing program, which is administered by the Registry of Election Finance. Section 3, we create a clean judicial elections fund, which will be funded primarily by income tax refund designations, checkoffs, as well as contributions that come from attorneys when they turn in their annual dues, Kentucky Bar Association. There will be no funds from the general fund. It allows for that, but that is not something that we're going to be doing anytime in the near future here. Section 4 requires the publishing of information prior to the judicial election so people know the average amount that they would have to spend to be competitive in a race. And then Section 5 sets out the requirements for these candidates who would like to participate in this program. Number one, they have to be willing to spend no more than $5,000, what we call seed money. This can be their money, their family's money, contributions. And then they have to obtain 200 qualified contributors who will contribute $25 to their campaign. So that's another $5,000. And then if they are qualified, they will be eligible to receive the Clean Judicial Election Fund monies.
Representative Reiner, let me let you catch your breath just to announce something to the members that I noticed wasn't noted on the agenda. This bill is for discussion purposes only today. There'll be no votes, so we're doing that, and we wanted to get it on today's agenda. We've got, again, nearly 100 bills to consider and more coming in judiciary, and we wanted to get this heard today for a couple of specific reasons, but I want the members to not be in a misconception, and now we're just going to discuss the bill today.
Thank you.
And let me say this: it's not posted either, and that was so. But that was a discussion beginning that we would not hear it for a vote. So
we appreciate the opportunity to be heard. Section 6 provides that if there is not enough money to distribute to the candidates, that they will be given the opportunity to withdraw from the public financing program after signing up, or submit to receiving a reduced amount based on an equal percentage of what is available. The next most important thing would be Section 9, which deals with penalties, which involve up to $10,000 in civil penalties. If it's a knowing violation, it's a Class D felony plus up to $10,000 for each violation. And then it also, in verse 10, verse 10, that comes pretty natural. Section 10 talks about the contributions that come from the designated income tax form. And then Section 11 allows members of the Kentucky Bar Association to make contributions that will go to the fund. I think now we would like to have some of those who have come. We have several professors from UK. I don't know whether they're both here. They're having troubles arranging their...
I think we're both here.
Oh, good. If you would come on up and identify yourself.
Thank you. My name is Josh Douglas. I'm an assistant professor of law at UK College of Law, and my specialty is election law. I teach an election law course, and I've written several articles about election law issues, particularly how courts go about deciding various election law cases. I'm also in the process of writing a casebook with two co-authors for an election law course. Today, I thank you for the opportunity to discuss briefly some of the issues that have occurred around the country involving elections for Supreme Court races, to demonstrate why I think this bill is a really important step for Kentucky to take. I'm also going to discuss how a public financing system can help to improve the diversity of who tries to run for office on the Kentucky Supreme Court. The first case I wanted to mention, which was already alluded to, was Caperton versus Massey out of West Virginia. In that case, an individual by the name of Brent Benjamin successfully unseated the incumbent for the West Virginia Supreme Court in an extremely expensive race. Benjamin had received $3 million in contributions from Don Blankenship, the CEO of Massey Energy, and related PACs that political action committees affiliated with Massey Energy, which actually amounted to over 60% of Benjamin's total campaign finances. Well, it so happens that Blankenship's company, Massey Energy, had a major $50 million jury verdict against it, brought by Hugh Caperton, who is the owner of a coal production company. And Massey sought review to the West Virginia Supreme Court, and it so happened that Justice Benjamin got to sit on this case. And in a 3-2 vote, after refusing to recuse himself, 3-2, Justice Benjamin voted to reverse the $50 million jury verdict. The plaintiff, Caperton, appealed to the U.S. Supreme Court, which did rule that it was a violation of due process for Justice Benjamin not to recuse himself. But I think the decision is interesting because it might seem like, well, okay, if there's too much of a conflict of interest, justice must recuse. But the court was very narrow in its decision. Justice Kennedy, in its 5-4 decision, wrote, not every campaign contribution by a litigant or an attorney creates a probability of bias that requires a judge's recusal, but this is an exceptional case. We conclude that there's a serious risk of actual bias based on objective and reasonable perceptions when a person with a personal stake in a particular case had a significant and disproportionate influence in placing the judge on the case by raising funds or directing the judge's election campaign when the case is pending or imminent. So it's narrow because the court says that recusal is only required in the exceptional cases where an actual case brought by the person contributing to the justice running for office is pending or imminent. So it only applies in very few situations. And I'm going to give you 2 examples of situations where I don't think even the Caperton Supreme Court decision would require recusal. The first is from the Wisconsin Supreme Court. The Wisconsin Manufacturers and Commerce, which is the state's largest business lobby, spent more than $2 million to help a woman named Ann Ziegler win an open seat on the Wisconsin Supreme Court. And after winning, she wrote the majority opinion in a 4-3 decision in 2008 that resulted in $350 million of tax refunds to Wisconsin businesses, which was a case that the Wisconsin Manufacturers and Commerce had helped to finance, the very group that had helped her win election. She refused to recuse, but it's not clear Caperton would have required her to, because it's not clear that it was an exceptional case where the organization knew it had this case that was pending or imminent before giving her the money. Similarly, the Illinois Supreme Court Justice Lloyd Carmeier received $4.8 million in contributions in his 2004 race, and $1.3 million of it was from State Farm Insurance Company, its lawyers, its affiliates, and its affiliates' lawyers. Judge Carmeier then voted to reverse a breach of contract verdict against State Farm, which the lower appeals court had upheld unanimously. And the St. Louis Post-Dispatch, interestingly, noted after this happened that, quote, the juxtaposition of gigantic campaign contributions and favorable judgments for contributors creates a haze of suspicion over the highest court in Illinois. This shakes public respect for the courts and the law, which is a foundation of our democracy. Now, we might think, okay, well, those are isolated incidents in those states, but the problem is now with the current campaign finance regime, the amount of money in politics, as I'm sure you all well know, is increased tremendously. The Supreme Court ruled in Citizens United that corporations and labor unions and other outside organizations can spend unlimited amounts of money on electioneering communications. And whether you approve or disapprove of this case, I think it's indisputable that it has resulted in a large increase of money in politics. So this makes this an important issue now, because even if we haven't seen extremely expensive Supreme Court races in this state, we will, because outside groups and groups within Kentucky will start spending a lot of money on judicial elections. And so this is why it's important, I think, to have a public financing scheme for judges to remove the ability, or at least provide one way in which individuals can run for office without having to collect large contributions from individuals or organizations. And this raises another point, which is justices should be deciding cases, not raising money. So every moment a justice has to, especially if they're an incumbent, has to campaign by raising money, it's time wasted not deciding cases. And they also may need to feel the need to raise a lot of money just to ward off potential challengers. For example, in 2006, 2 incumbent justices in Michigan raised a combined $1 million despite barely having any opposition for the seats. If there was a public financing scheme, they wouldn't have to worry about that. They would know they could be adequately funded for a race. And further, the public believes that those who give to judicial campaigns are seeking something in return. One study I found said that when the public is asked, 9 out of 10 responded that special interest groups are mobilizing courts to promote their own agendas. And the last point I wanted to make is that privately financed elections, privately financed, where you have to raise your own money, alter who decides to run for office. Chief Justice Roberts, on his first report on the federal judiciary, talked about judicial salaries, and he said, There will always be a substantial difference in pay between successful government and private sector lawyers. But if that difference remains too large, as it is today, the judiciary will over time cease to be made up of a diverse group of the nation's very best lawyers. Instead, it will come to be staffed by a combination of the independently wealthy and those following a career path before becoming a judge different from the practicing bar at large. Such a development would dramatically alter the nature of the federal judiciary. I think the same thing is true with respect to the state judiciary and who runs, because under the current system, really only those who are able to run a viable campaign are those who are independently wealthy or who have ties to people who are independently wealthy to raise enough money to run a successful campaign. So public financing of judicial elections would even the balance, because it would allow those who don't have independent financial backing to run a viable campaign to win a seat. And I think this would improve diversity of experience and background on the Kentucky Supreme Court. So assuming we're going to continue electing our judges, adopting a system of public financing for the Kentucky Supreme Court is an appropriate response to the increased amount of money in politics. It will help ensure that there's not even an appearance of bias in judicial decision-making, which will help the public's respect of the judiciary. It'll ensure that additional qualified people are able to run viable campaigns, and it will help make sure that the court continues to be viewed with the highest integrity.
Professor, would you entertain a question
Sure.
while it's hot on the mind of Representative Crenshaw?
Thank you very much. And Representative Reiner, either of you can address this. I thought I heard Representative Reiner say this would be applicable to the Supreme Court of Kentucky.
That's my understanding, is that the bill currently would just apply to the Supreme Court.
Well, why not all appellate courts and Court of Appeals? And well, I'm hearing my colleagues say don't have the money, but wouldn't the Court of Appeals be just as susceptible to the same things that the Supreme Court would be?
It sure would, and we would like to expand it. If we can, this is more of a pilot project. Okay. If we can do it at the Supreme Court level, which is, perhaps that's the place that we can do the most good, then we'll definitely expand it.
And let me also say that the special interests target Supreme Court more than lower courts, because Supreme Court cases set out various policies that will be applicable in future cases. So, for example, I know the insurance industry is one that does spend a lot of money in judicial races in states like Louisiana, and particularly state Supreme Court, because the Louisiana Supreme Court sets out, has a lot of cases involving insurance issues, and so the insurance lobby particularly targets that. But I think your supposition is correct that this would apply, or this would be a concern for other appellate courts. But I think that it's most concerning because of just the sheer amount of money involved in state Supreme Court cases.
Thank you, Mr. Chairman.
Good question. Representative Owens.
Yeah, thank you, Mr. Chairman. I think it's a great piece of legislation. But is this voluntary if I'm going to run for the Supreme Court?
Yes.
So if let's say I've been a big defense lawyer for the insurance company for years, and I'm running, and I know that probably I'm going to get a pretty nice amount of money, it wouldn't make sense for me to be a part of this, would it?
Well, it depends on how much you value being a recipient of the clean campaign. I think that has value in itself. Well,
it very well may, except that when you run in a race, the amount of money you have to get out your message and gin up your support is as important as anything else. And as a matter of fact, I can overcome the message when you say he is not a clean, clean government candidate. I think I could overcome that. And I think it's a great piece of legislation. I'm just not sure how you get it work unless you require everybody to do that. And I don't know where you get the money if you're going to require it.
The problem is you can't require everyone.
Right.
That would violate the First Amendment, because individuals have a right to spend whatever money they want. I think the point here is that because you can't require, and because the bill, the amount of funding in the bill is tied to the amount spent in the previous election, then those running under the public financing scheme at least will have a decent shot. Now, can they outspend someone who's backed by wealthy special interests? The answer is frankly no. But that doesn't mean it's not worth giving someone the ability to have a viable campaign. And I think the part that ties it to previous election spending helps mitigate that disparity. But I mean, frankly, under the First Amendment, if someone wanted to spend gajillion dollars on a race, they could.
Let me ask one other question. Do you have an idea what the latest Supreme Court case cost?
I don't.
I don't either.
No, but we know that it's
I know it's expensive. But
it's going to be going
up,
getting much more costly.
And I think that the fact that the Citizens United decision applies to judicial elections, which is not something that a lot of people are thinking about, but it is the reality. Because people think about sort of the more high-profile cases and the presidential election this year and the super PACs spending money. But that case, all the principles from that case applies with exact same force to judicial elections.
I believe Representative Hoover and then Representative Nemes.
Thank you, Mr. Chairman. A couple of questions. First of all, Representative Reiner, this morning I watched the Banking and Insurance Committee meeting on TV, and Representative Dameron, a member of the majority leadership in the House, expressed his frustration, Mr. Chairman, with judges and judicial decisions, and I think he basically said they had too much power. I think he used the word discretion, but said they had too much power, and he had no faith in judges or the judicial system. I really don't know what would prompt him to say that, but I was just wondering if there's anything in this bill that might help alleviate his concerns or his issues.
Well, I think that the fact that we are providing an opportunity for people perhaps that are not well funded, they're not independently wealthy, but they have character and ability. We're providing them with an opportunity to think about running for an office that perhaps they wouldn't otherwise. And I believe that we're helping to restore public trust by offering this type of legislation. Some states are passing legislation to give the governor power to appoint members of the Supreme Court. I don't think the people of this state would be very happy with that. So this is probably something that I think can get more mileage in terms of actually helping to create a better environment for public trust.
Follow-up question.
Sure.
Professor, I think it was last week or week before last, I noticed or read an article, and you may have mentioned this, where two Supreme Court justices, United States Supreme Court justices, have indicated their belief that Citizens United should be revisited. And I believe that case is out of Montana. Out of Montana. Your thoughts on that, just from being a student of maybe this issue in the Supreme Court? Do you think the Montana case is a case that will allow them to revisit the entire issue?
Well, so let me tell you my biases here, which is I sure hope so.
Okay.
And my practical perspective, which is there's no chance in it. The two justices who said that, Justices Ginsburg and Breyer, were both in the dissent in Citizens United. Citizens United was a 5-4 decision, with Justice Kennedy being the swing vote. I would be surprised if Justice Kennedy was going to reverse himself. Now, that said, I think there is some room for a limitation on Citizens United. So that case involves a Montana campaign finance regime, and Montana is saying one of the reasons they're justifying is they have a unique history of corruption from corporations and outside interests in their elections. And I could see Supreme Court saying, well, if a state can demonstrate a unique, different kind of history of corruption, then maybe that's a little bit different. But if I was a betting man, I would predict that this one will not lead to a reversal of Citizens United.
Well, I certainly agree with your analysis, at least from a practical standpoint. Thank you.
Well, before we go any further, I know Representative Nemes, Professor Fortune, I know you came to speak today, so have a seat here. I know we need a number of members express that. And
Josh is the expert on this.
All right, well, Well, we certainly want to hear. And we do have a bit of a time crunch here because we have, and I apologize, but my Representative Nemes.
Thank you, Mr. Chairman. This is more of a statement. If you don't have to get in this program, then I don't see how it addresses the problem, or that the man in whatever state wouldn't take his $3 million anyway. And who determines if it's adequate funding? Next thing is, if we have staggered elections, so one election they may get nothing, and then the next election we have public funding. Do you want to make a comment on my statements there?
I don't particularly. I mean, I think that your point is well taken, that maybe the formula for determining how much money is available in a particular race needs to be tweaked a little bit, and that's something that perhaps you could work with, the committee could work with Representative Reiner, Representative Wayne on. I do agree with that. I think the question of adequacy, and that is a reason I think that it's at this point limited to the Supreme Court. All that is provided for, of course, are mechanisms by which it might be funded, tax refunds, contributions by members of the bar, and so on. There's no appropriations, whatever money the General Assembly would like to appropriate, but there's nothing set out there. So the question was, okay, would we want to create a plan here, which might mean that the pool of money is so small that no one would opt in? And that was the thought. Now, I believe that maybe the representatives could react to this. I believe it might be not a stretch to extend it to Court of Appeals judges. Not to extend it to the trial court level, but to extend it to Supreme Court and Court of Appeals, because that's a fairly limited number of races that you're talking about. I think that point is well taken. The only thing really that I've got to offer is this. I've been involved with this. I do not teach election law, but I've been involved with the issue of fair judicial races since 2006, through working with Chief Justice Lambert and then later with Chief Justice Minton, and working with what we call the Judicial Campaign Conduct Committee, which is the Citizens Committee, which took a very, very active role in trying to influence the 2006 judicial races to be more civilized, shall we say. And I think we accomplished that goal. And it's been a continuing organization that's kind of kept me involved in this issue. What I would see is this, the benefit of taking this, maybe baby step towards public financing of judicial races is this. For one thing, the system, and I think it probably is patterned on the North Carolina system, is designed to require the participating judge to have a fairly broad-based support, financial support. It's called a $25 qualifying contribution here. That might be too high, I don't know. But in any event, 200 people have got to pony up $25 to be a part of this. So what it does is it says to the judicial candidate who wants to participate in this kind of thing, you've got to have a broad base. And when you've got a broad base, you do not have the appearance of being beholden to anyone. Now, that I think is important. I think in terms of the effect of this, what it would do, I hope, is it would send a message to judicial candidates that this is kind of the way to go. And they would like to do this if possible. Now, the individual, the candidate that's got $5 million sitting on the table might not feel that way. But it would be this is what we would like you to do. And if you do this, you could campaign as a clean elections candidate. And North Carolina's experience has been that most of the judicial candidates do opt in. And also in North Carolina, most of the campaign contributions do not come from PACs, nor do they come from lawyers. Now, that takes me to this, and I think this would be a great advantage of it. Admittedly, more of an advantage at the trial court level than at the appellate court level. But what it would do would be to take both lawyers and judges out of the loop of the semi-required contribution to a candidate who's running for office. Maybe both candidates are running for office, because you as an attorney are going to have to practice before that judge. And to the extent that the judge's financing could come other than from lawyer contributions, then what that would mean is the judge wouldn't feel as if he or she has to ask lawyers for contributions, and the lawyers wouldn't be subjected to what I think we all perceive to be pressure to contribute to a candidate. I don't think either the judges or the lawyers like that system. Now, admittedly, that's more of an issue on the local level, but if we took this kind of baby step at the appellate Supreme Court and maybe the appellate court level, we might in time convince the General Assembly that this is something that's worth funding, so there would be enough money in there to cover district court and circuit court races and family court races as well. And the only other thing I would say is this whole business about perception. Josh quoted you some statistics about the public perception about the impartiality of judges who receive large campaign contributions. When they do polling, they've always found that the public is cynical about that. I chaired a panel at the KBA convention that had Justice Noble on it and it had John David Dyke on it. And the question was recusal of those judges who receive campaign contributions through PACs or otherwise. And both Justice Noble and John David Dyke, we all know, said, well, yes, of course, the public thinks that. And Justice Noble was saying it, of course, in the context of, and I believe that's a real problem, because what it means is that the public may think that I'm somehow on the take because I received a campaign contribution. That is not the case. But I don't like to be in that position. So I would say that even in this state, we've been saved from the worst of it. We have not had the West Virginia campaign here. We haven't had the kinds of campaigns that they've had in some of the southern states, in Ohio, Wisconsin, and so on. And I just thank God we haven't. I just thank God that our judiciary, both particularly on the Supreme Court level, has been saved from those kinds of attacks. But I think and hope that this would be perhaps a baby step towards inoculating us against that, to keeping those folks at bay, as it were, who would come in here and try to influence our elections by pouring a lot of money in to try to convince a judge or justice who's running for the court to vote in a particular way. So that's my 2 cents for what it's worth.
Okay. We're going to take one more question if we could, and if you press, if you want to follow up. Representative Gregory had a question. We need to move on to the last. We do need to take a vote on House Bill 239, which we'll be hearing in just a minute. So.
Thank you, Mr. Chairman. I'll be brief. First, as a former student, I just want to welcome Professor Fortune. He was my professor in evidence and professional responsibility, and I probably owe you a little credit that I've made it, at least to this point in my legal career, without a bar complaint. So.
Done it in spite of me.
But I also had a question that I wanted to ask to anyone on the panel, and perhaps to Professor Douglas as a sort of the election law expert. Even if Kentucky were to adopt some type of public financing system for these judicial races and a candidate were to opt in, with Citizens United and some of the other case law that's out there, is there anything that would stop an outside group, a 527 super PAC, something along that line that we hear about, from coming in and still spending $1 million advocating for a candidate, even though the candidate had opted into the public financing system?
So the brief answer is no, nothing would formally stop it. The more nuanced answer is if you believe in Citizens United and you take what the majority in that case said at face value, those outside groups are not coordinating with the campaign. They have nothing to do with the campaign, and so there can't be this quid pro quo corruption that we're concerned about. Now, if you're more cynical about the Citizens United decision like I am, you say, well, there's still some, if I'm a candidate, I know who's helping me out, but at least they're not contributing to my campaign. But there's even something further that can be said, which is if candidates are really into running clean elections, they can do what Scott Brown and Elizabeth Warren are trying to do in Massachusetts in their Senate race, which is they've come to an agreement which says we're going to ask all of the outside groups that support us not to spend money in our election. And if one of them does, we will then donate out of our own personal funds to a charity of our choice. And so the outside groups basically know, look, if we're going to support our favorite candidate, that person's going to be out money, and it's sort of an agreement, a negotiated agreement that they had. Now, Citizens United says that these outside groups have First Amendment right to spend what they want, so you can't stop that. However, this is, I think, a really important step to at least make the money not all about who's got the outside groups in favor of you, but who can opt into this system and at least have some ability to run a viable campaign for themselves. And then just briefly to address the point of why would anyone opt in if I've got $3 million coming to me? Experience in other states have shown, as Bill Fortune mentioned, experience in other states have shown that candidates still do opt in to public financing, even if they have the ability not to and get a lot of money. And public finance candidates are able to prevail. So, yes, not everyone's going to opt into the system. It doesn't help solve the entire problem, but I think it's a good step in the right direction.
The statistic I have is that 92% in North Carolina did opt in, and that it's a pretty high percentage. I would say this too, kind of along those lines. If you opt in, you can bill yourself as a clean election person. If you opt in and are billing yourself as a clean election person, and then there's a huge amount of money that's dumped by a special interest group to attack your opponent, it obviously raises the question of whether or not it's hypocritical of you to continue to campaign that way. So I think there's kind of a downside to perhaps, as Josh suggested, perhaps a reluctance on the part of a candidate to accept that outside money in the event that the individual opts in. I think that's something that would be at play here as well.
Okay, we're counting down now, so briefly.
I'll make it very quick. Professor, and I cannot remember the justice that made the comment that money was not speech, that money was personal property. I can't remember. He's retired now. I forget which justice it was.
O'Connor, then, potentially.
I don't think it was O'Connor. It was it Stevens? But it doesn't matter who it was. But my question is this. I can somewhat understand if you're wealthy and you spend your own money. I can halfway understand that. But how do third parties like the Citizens United and the super PACs, how does that become speech of the candidate?
It doesn't, which is why the Supreme Court said it's unregulated. It's unregulable. It's because the Supreme Court has said Congress can only regulate campaign finance speech if there's a concern about corruption. And if it's someone's own speech that's not coordinated with the candidate, the Supreme Court has said, well, that's their own speech, and so they can spend their own money on their own campaigning for whatever issues they want to campaign. So, and that's sort of the different views of corruption. If you believe that corruption is only about quid pro quo, direct quid pro quo corruption, then you'd say these outside groups should be able to spend their own money on however they want. If you think that corruption is a little bit broader, and we should understand corruption to be, what, in my view, how it actually might work, then you might be more concerned. I don't know if that addresses your question.
It does somewhat. It helps me some. Thank you, Mr. Chairman.
Well, we probably haven't seen the last of this issue, and so we'll appreciate you all. And sorry we're out of time. We need to move on, and certainly, Professor.
He didn't say it, but Josh Douglas greatly appreciates, since he's teaching election law, being able to use the General Assembly's redistricting.
I'm sure that's right. Well, I hope that's a good.
It's going to be a good issue for class discussion.
Give good fodder, right? Good case study. Well, at least glad we could help. Glad we could help out. Well, let's thank you all, three of you. Appreciate it.
Okay, the next bill is House Bill 230, Representative Wayne. An act relating to public financing for judicial campaigns and making an appropriation therefore. Is there a committee sub on this one?
There is not, Mr. Chairman, but we can't take a vote until the chairman comes back. So is he due back momentarily?
I don't know. Why can't we take a vote?
It's self-explanatory,
It's essential that
Brent.
the chairman be here.
It's self-explanatory, Brent.
I'd be glad to explain the bill while we're waiting for him to return.
100.
Well, this is.
He's coming back.
You've already had it. You've heard. Oh, here we go. Oh, I'll be
Move
glad
passage. Move passage.
We got a motion and a second on House Bill 230, Representative Wayne's bill. There's no committee sub, so we'll take questions now.
All right, remember I'm back in the saddle. There's obviously some concern. I told them facetiously that I quit, and I guess they took me at face value.
I thought you was going to be the deciding vote here, maybe.
Well, possibly so. House Bill 230. Members, any questions, concerns? We did have an informational hearing. I guess it's been about 3 weeks, Representative Wayne, and you were actually unable to be here. You had an obligation, so I think Representative Reiner stood in for you, if I remember correctly, and did an able job. We aired a lot of the concerns and questions at that time, so that's, for those of you just tuning in, that's probably why we don't have any now. We can proceed, I think, at this point with a vote.
Representative Bell?
Yes.
Representative Crenshaw?
Yes.
Representative Fisher? No. Representative Flood? Yes. Representative Gregory?
No.
Representative Hoover?
No.
Representative Jenkins? Yes. Representative Kerr?
No.
Representative Lee? Representative Marzian? Yes. Representative Nemus? Representative Owens? Representative Reiner?
Yes.
Representative Rudy?
No.
Representative Yance?
Yes, now explain my bill by understanding his comments wanted the chair to come back.
Chairman Tilley?
Yes. Just to make sure the count's correct, is that 9? Bill shall pass a favorable expression by a narrow margin.
Thank you, Mr. Chairman. Thanks for returning.
Well, no margin for error.
Thank you, members.